Good afternoon, everybody. Glad you guys are here. We're glad everybody is joining us either here in person or virtually by Zoom here at Parker Poe's offices for the Charlotte Triage's 6th annual training program. My name is Chip Ford. I'm a partner in the Financial Restructuring and Insolvency Group here at Parker Poe. Kind of pinch hitting for my colleague, Nicholas Lee, who works with Triage and sort of helps to coordinate all of this, but is unfortunately out of town today. You guys are in Parker Poe's main office in Charlotte today. As I think many of you guys know, Parker Poe, we have 8 offices throughout the Southeast, and this is the main one. We've got about 300 lawyers. Can't remember how many work in this office. Today's session is focused on the expungement of criminal records. And I know from past experience and having attended this training session in past years that you are going to get a lot of extremely helpful information at this training program. I have handled a number of expunctions myself with the help of the folks at CCLA. The materials, and I don't know what the program for today is. I don't know what's planned for the program today, but in years past, it has been extremely practical and has resulted in getting a lot of helpful documents and forms and other information that are a critical toolkit, and really, quite honestly, have sort of everything that you would need in order to sort of get started doing these things. So I think this is going to be a valuable time for everybody. So without further ado, I'll hand it over to our presenters from CCLA and let them take it away.
Thank you, Chip. My name is Courtney Vbrock. I am an attorney at Charlotte Center for Legal Advocacy. I'm going to try not to fall here in the first couple seconds. I'm pretty new to CCLA, but I practiced in the criminal law world for a while. So this criminal record stuff is not particularly new to me. I've been at CCLA since about March, and I will be sort of transitioning to take on some of Casey's roles as she's leaving us in the next coming in weeks and things like that. You'll hear from Casey later when she makes her case for why you all should take a pro bono case. And I'll let Madeline introduce herself as well.
Yeah. Hi, everyone. I'm Madeline Smith. I am the paralegal with the Community Empowerment Project at CCLA. So I really do anything that Courtney needs and that can help out with these cases. I'll be doing a little bit more of the how to read a criminal record and fill out some of the forms. And Courtney will be handling all of the other juicy law details.
Yeah. For anybody who's not familiar with our organization, Charlotte Center for Legal Advocacy is a nonprofit legal services organization. Like Madeline said, we're in the Community Empowerment Project. Expunctions is probably the biggest work that we do. We also do a little bit of driver's license restoration and some property tax relief, mostly for elderly Mecklenburg County homeowners. And the organization itself does a lot of other incredible work. Some of your colleagues are probably at different trainings around the city that are being run by CCLA and other nonprofit organizations around the city. So we really rely heavily on pro bono attorneys. We are so grateful for you all for being here and being willing to learn about this subject matter and hopefully take a case. So I thought I was clicking forward and I'm not. All right, so this is just our mission and our vision. And like I said, oh, thanks. No, okay, sorry. We're really grateful to you all for volunteering your time, taking this time with us. Really, I think the greatest thing that we can do is have an interaction with our clients that's a good one within the legal system, and having lawyers in front of them that are advocating for them and not feeling like they're being oppressed by the legal system is great for the legal community and for the client base as well. And I can tell you that these are some of the happiest clients you will ever talk to. When you finish handling their pro bono expunction case, they are just thrilled. I had someone nearly blow out my eardrum. She was so psyched about getting her expunctions granted. So there we go. This is our agenda for today. I'm gonna kind of just start with some introductory information. We're gonna talk about how to determine the eligibility of different charges on someone's criminal record, how to read their criminal record. If you do take a case with us, you're gonna be given all the information about all the criminal activity that's gone on in their record. And it's pretty tough to read, at least initially. You'll kind of get used to it if you do end up reading a record, but we are going to walk through that as well as drafting petitions. And through those 3 sections, you'll kind of see how the data migrates from the criminal record onto the petition and then to the clerk's office. We're going to talk a little bit about what's in our Expunction toolkit, which is on the CCLA website. Some other relief that's available if you're talking to a client and you realize they may have some other services related to their criminal record that CCLA or a pro bono attorney could provide them. And we'll just talk about handling a case step by step, basically what we would expect of you if you were to take an expunction case, and we'll have a little time for questions. I'll go ahead and warn you, I have put some images in the PowerPoint presentation, mostly for my own amusement, but somewhat for yours too, if you can get any of the niche pop culture references that I've put in there, bonus points to you. There we go. So an expunction is, most people I think know of it as an expungement. In North Carolina, we call it an expunction. It's just the destruction of a criminal record by a court order. Why is this important? Basically, this is a huge barrier for people who are trying to get housing and employment. That's why we do this. We're trying to remove those barriers. We're trying to get criminal justice involved individuals to re-enter society in a meaningful way. And this is one of the main ways that we can do it. You can see there's some stats on here, but they're pretty, I would say, common sense. Employers and landlords are less likely to give housing or employment to someone who has a criminal record. And people who are entitled to have those records expunged are able to avail themselves of a lot more meaningful opportunities in society if they can get those things off their record. So North Carolina technically has 16 expunction statutes, but we're really mostly going to be talking about 3 today. There's been a lot of movement in this area of law towards allowing people to expunge more criminal records, more of their criminal charges. So of those 16, most of them at this point are obsolete because they've expanded relief so much under these 3 statutes. So that's mostly what we're going to be talking about today. At the end, we'll touch on certificates of relief and motions for appropriate relief. These are kind of alternatives to expunctions, things that we might be able to do for people who aren't eligible to have everything or to have some things expunged. So determining eligibility is basically a logic game, as I'm sure you'll all remember and love from the LSAT. This section is essentially just going to be giving you the logic games rules. I've tried to boil them down in a way that's more digestible, a little less intimidating. There's always, as you all know, you're all lawyers, like a million exceptions. There's different things you're going to see if you take a case that aren't specifically covered by this portion of the presentation. We have more information on how to handle those little nuances, but this, for purposes of today, is just sort of the logic game rules. This is how you're going to look at a charge and decide whether or not it's eligible for expunction. The most common, easiest expunctions that we do are dismissals. This is our bread and butter. Dismissals actually do show up on criminal records in North Carolina. Most people who are non-lawyers and some people who are lawyers don't know that there's a difference between a charged criminal offense that was dismissed and a conviction. And we'll just see anything on a record and feel free to, write that person off, not give them a job, not give them housing. So this is one of the things, it's actually one of the simplest things to talk about, but it's one of the biggest and most important things that we do. We're also going to talk about acquittals and not guilties. Those are also pretty simple. And youthful convictions and adult nonviolent convictions. Convictions are kind of a different world. You may or may not, if you take a case, ever have to handle these. The rules are a little more complex for these. And there's the hope that someday the relief will be expanded under these, but we're just going to be talking about the law as it is now, and what kinds of misdemeanors and felonies people can get expunged under those statutes. So the first thing you want to think about when you are deciding if a charge is eligible for expunction is the disposition. It has to be a final disposition in order to have it removed from a record. I'm not going to go through this whole list, But basically, if it's on this right side here, pending, ineligible, it's gonna be ineligible. There are some other things we can do for people who still have pending charges, particularly older pending charges. But we're gonna be focused mainly on cases that have a final disposition. So for dismissals and acquittals, the disposition is gonna be voluntary dismissal without leave, not guilty, dismissed by the court, and dismissed pursuant to deferred prosecution or conditional discharge. If any of these dispositions appear on a charge, it's eligible for expunction. There's really nothing else that can disqualify them. Previously, under North Carolina law, if you had a felony conviction, you couldn't have any of these expunged, and now you can. It really takes people's records down from this hundreds of pages of charges to very few, if any at all. So this is why this is a big part of what we do. They are also almost always mandatory. So a judge doesn't have discretion of whether or not they grant an expunction for a dismissal or an acquittal. There's no waiting period. There's no limit on the number of times you can petition for these kinds of expunctions, unless it was a charge that was dismissed per plea, which we'll talk about how to identify that on a criminal record. It's basically mandatory. A judge has to grant it. The only caveat being that infractions, technically traffic infractions, are non-criminal offenses and aren't eligible. There are some counties that grant them anyway because it's easier for the clerks if you put them on the petition. But that's a nuance that if you take a case, I'll talk to you about that. So for convictions, the disposition is going to be either guilty, prayer for judgment continued, or Alford. Does anybody remember from law school what Alford is?
Oh, I also used to practice criminal defense in a prior life.
There we go, there we go.
Yeah.
Alford, I put it down here in little print, but it's basically the client admitted that there was enough evidence to convict them, but they maintained their their innocence. That is going to be treated as a guilty plea or a conviction for purposes of expunction. So if you have one of these three dispositions on a charge, the classic lawyer answer is it depends whether or not it's going to be expungible. And the first thing you're going to look at is how old the person was at the time of the offense. If the person was 16 or 17, they'd be classified as a youthful offender, and you're going to proceed under that statute. If they're 18 or older, that's going to be treated as an adult conviction. So first, we'll talk about these raise the age expunctions. They're called raise the age in North Carolina. That's what they called these legislation that was passed basically to raise the age at which someone is charged an adult from the age of 16 to the age of 18. So it also created this avenue for anybody who was convicted when they were 16 or 18 prior to the legislation being passed to have those records expunged the same way that they would have been had they been convicted after the legislation was passed. Expunction under this statute is mandatory. And the criteria are that the date of offense be when the individual was 16 or 17. The severity of the crime also matters. So it's class H and I felonies. We'll talk a little bit about sentencing in a minute. And misdemeanors except for sexual battery. Again, there's a bit more nuance in here, but these are the main ones that we see. And then the timing for this kind of expunction is upon completion of their sentence. So the second they're done with their probation, they paid their restitution, they can have these charges, these convictions expunged from their records. As you see at the bottom, there are offenses that are not eligible. These offenses basically represent all the offenses that juveniles will carry on their record, even if they commit these crimes when they're juveniles. So it's sort of just leveling the playing field. For adult convictions, it's going to be a little bit more of a naughty examination of the record. But basically, there's four things we're going to be looking at: the severity of the crime, the number of charges, the timing, as in how long ago it happened, how much time has passed since that person has had a clean record, and then whether or not they have other convictions that might be disqualifying. So we're just kind of going to go through those criteria a little bit here. The legislature has deemed these misdemeanors and felonies that you can expunge as non-violent. So they've statutorily defined what violent misdemeanors and felonies are versus non-violent. And the non-violent are what you can get removed from someone's record. Again, we'll talk about disqualifying offenses in a minute, but any misdemeanor that's not disqualified is eligible to be expunged under this statute. If you are trying to expunge one misdemeanor, you need to wait 5 years from the completion of your sentence. If you're trying to get 2 or more misdemeanors expunged, you need to wait 7 years from the completion of your sentence. And there is no limit on the number of misdemeanor convictions that are eligible that you can get expunged. The last criteria being, again, that you can't have any disqualifying convictions, and we'll get to the list of those in a minute. For felonies, you can only have up to 3 expunged, and they can only be H&I felonies that are not disqualifying or disqualified. No felony convictions during the applicable waiting period, and no misdemeanor convictions in the 5 years before filing the petition. That would be the timing of things. For one, it's going to be 10 years from the completion of the last felony sentence. And for 2 to 3, it's going to be 20 years from the completion of the last felony sentence. That's for the felonies that are on the petition. Something to note here, occasionally we'll have a client who has more than 3 eligible felonies, and we have to go through their record and kind of decide which ones it makes the most sense to take off their record, which ones basically look the worst to landlords and employers. But all of those 3 felonies have to have been committed within a 24-month period. And again, in order to have any nonviolent felonies expunged, you'd have to have no disqualifying convictions. One note before we move to disqualifying convictions, multiple convictions that occur in the same court session are treated as one. So a lot of times an individual will plead to, say, 3 counts of breaking and entering on the same day in court. That only counts as 1 conviction. You can expunge all 3 of those and it only counts as 1. And when we go through a record, we'll show you kind of how we've come up with a way to conceptualize things so that you can see that all out in front of you, even if the records are all over the place. So for timing, the clock starts on the waiting period when the individual has completed all conditions for all their sentences that they're petitioning to have removed from their record. This would include the payment of restitution as represented by a civil judgment. A lot of times someone might finish their probation, but they don't have enough money to pay the restitution. The judge will convert it to a civil judgment, but they'll end their probation. That person still has to finish paying their restitution before the clock can start on their expunction waiting period. It's mostly going to be one of these dates, which I see I said a couple times there. It's either going to be the disposition date. That's going to be for crimes that were sentenced to a fine only and the person paid it for that day. Mostly it might be the disposition date plus the length of probation, might be disposition date plus active sentence if they served time, plus post-release supervision, or it might be the date of the final restitution payment. Figuring out which date this is can be tricky. That's kind of what we're here for. We will assist anybody in getting case details and interpreting what those say. And to the extent that, the client actually remembers what date their probation actually ended, then we wouldn't need to jump through all those hoops. But this is just sort of a reference slide more than anything else, so that if you do come up against this situation, you can kind of look and logic game it out and try to figure out when their time actually started. So these are the disqualifying convictions under the statute. This is not an exhaustive list. There are several more, but we rarely, if ever, see them. So I've put up here the most common ones that we see. A through G felonies are going to be the most serious crimes that we have in North Carolina law. Class A1 misdemeanors are the most serious misdemeanors. Offenses that include assault as an essential element are going to be disqualifying. This is a big one that we see a lot. Simple assault is technically a class 1 misdemeanor, but it will disqualify someone from having anything expunged off their record. That's a conviction. That's an adult nonviolent conviction. Breaking and entering is also a disqualifying conviction. Sex-related and stalking offenses, and then there are some enumerated drug crimes that are also listed as disqualifying. So you're going to want to keep an eye out for that. And we'll talk a little bit when you look at your record, how to kind of conceptualize it, flag these things, and then go through the record again and see if anything can be done about anything else. A note on out-of-state convictions. These can also be disqualifying. We can't expunge, obviously, South Carolina convictions from someone's record here in North Carolina. We're not barred to do that. We don't know exactly what the rules are there. If someone has out-of-state convictions, it would appear on their Lexis record, which we do provide with a case file. If you were to take a case in North Carolina, any felony that's out of state is going to automatically be presumed to be an H or an I felony, which is an eligible charge, would not technically be disqualifying right off the bat. However, if you were to have a hearing, the DA's office would come in and have an opportunity to prove that if you're to transpose the elements of this crime that this person committed at the federal level or in another state onto North Carolina law, then it would be disqualifying. So we do want to look at these out-of-state convictions to figure out whether or not we're going to have a fight from the DA's office. A lot of times it's pretty clear their crime matches up almost exactly with one that we have in North Carolina, and we can say for sure, yeah, the DA's office is going to fight this and we're going to lose, or we're going to be able to pass through as if it were a North Carolina conviction. And the last thing I'll note on this slide is that for federal charges, there is no federal expunction law. They do sometimes do pardons or they'll seal records, but those things are pretty rare. So if someone has federal charges or federal convictions, that is usually a tough thing for us to handle. It doesn't mean we don't take all of those clients. It means that we have to sit down with them and explain to them, look, we can get all your dismissals off your record, but we're really not going to be able to do anything about the convictions. And honestly, people are usually just grateful for any kind of legal advice that's coming from someone who's on their team. So the last couple of things I want to say about adult convictions, DWIs are not eligible for expunction, but they are not disqualifying. So if you see a DWI on a record, know that that person is going to have to live with that DWI on their record, but it's not really going to affect their eligibility for other things. Traffic offenses, including DWIs, for example, will not reset the clock on the waiting period to get an expunction. Nor will payment of any kind of court costs or fees or meeting any conditions of a DWI will still allow you to get other things expunged. Pending criminal charges are also going to prevent someone from getting an expunction under the adult nonviolent convictions statute as well. So that's just something to look out for on a criminal record. You'll see that by noting that there's a future court date on the record. And we'll look at that in a minute. So North Carolina has structured sentencing in place. Basically, the classification at the time of the offense was committed is going to be what determines someone's eligibility for expunction. Mostly, we're going to be looking at crimes that were sentenced under structured sentencing. Much older charges were sentenced under a different system, but they'll essentially be treated the same way for the expunction statute. So misdemeanors less serious, felonies more serious. For misdemeanors, they're classified as 1 through 3 and A1. And for felonies, they're classified as A through I, A being most serious, I being least serious. Figuring out what offense class someone was sentenced under seems like it should be a really simple thing to do, but sometimes it's not. These are the two ways that we've figured out to best decide how someone was sentenced. When you look at someone's record, there's going to be a column called law. Frankly, I just highlight the law that they were sentenced under and I Google it, and the statute itself will say this is to be sentenced as a class 3 misdemeanor. The other way is that there are 2 PDFs that state of North Carolina has put out with felony and misdemeanor classification lists. You can control F inside of that document and it will tell you exactly what class it is. This is most useful for drug offenses because the drug sentencing statute is really difficult to read if you've never practiced in that area of law.
And where do we find that?
So that's going to be in the Expunction toolkit. It's on our website. We'll send links and passwords to all that stuff if you do take a case. For traffic convictions, there's kind of 3 categories. When you're looking at a record, you may have someone that has a bunch of traffic convictions. So this is good to know for those individuals. Infractions are non-criminal and essentially not eligible. Like I said, some counties will still grant them if you put them on a petition. There are traffic misdemeanors and felonies. Those are going to be eligible. You're going to assess those the same way that you would any other criminal offense. And then, like I mentioned before, DWIs are just not going to be eligible. Oftentimes, criminal charges and especially traffic charges are going to be multiple charges under one case number. If one of those charges is eligible and the other is not, that's called a partial expunction. We do not, as an organization, petition for those at this time, at least, because the DMV system, when they go to log a partial expunction, will relog the other charge as a new charge and suspend a person's license, and then they'll get pulled over for driving while license suspended, and it's a whole mess. Generally, traffic charges are not what's preventing people from getting housing and employment, so we just don't really touch those, at least for now, until the DMV does better, I guess. Okay, I'm gonna let Madeline take over here and just talk a little bit about how to read a criminal record. Extra points, I feel like some people recognize this. This is what it feels like if you look at too many criminal records.
Yeah. Very accurate. Hi, Madeline, once again. So I handle a lot of the pooling of the criminal records from the Cypress system, which is our non-certified statewide background check. It's based on the demographics of the client, so their name, date of birth, race, gender. We can also, look at their aliases, addresses, things like that to verify that it is the client that we're dealing with. We don't do the certified statewide background check because there's so many hoops to jump through, and it can delay cases. The clients have to pay a filing fee and get their fingerprints done from the sheriff's office. So it's just a big burden on the client. So we've moved away from doing the certified statewide. So we will provide 2 sources of non-certified background checks, and that's the Lexus record and the Cypress record. Yeah. Okay. So this is an example of a Cypress record. So the most important parts are already highlighted in yellow, and we'll kind of go over those so you know what you're looking for when you're trying to make your determination spreadsheet. So at the top, does this work? You can't really see. So at the top right, where it says Davidson, that's the county, North Carolina County, and then the case file number, the client's name, and then the top information is the case information. So that will be where you see the jurisdiction, which you also see later on. You see the offense date, the case was served on date, which oftentimes is the same as the arresting date of arrest. Court session date over there, that proves that it is a pending charge because it has an upcoming court date. It also has information down here for the defendant that includes, addresses, aliases can even show up over there. And that's good for when you verify with the client that all the charges that you're seeing are correct and complete, that will help them to know if it's been 20 years since this charge occurred. You might have to remind them, okay, did you ever live at this address? And that can help verify that it's their charge. This is the second half of the sheet. It will have the arresting agency to the right. So this would be the Davidson County Sheriff's Department, which we have a list of the arresting agencies and their addresses that you can then verify when you're filling out that part of the expunction petition. And then we also have the actual case information. So for the criminal charge in question, there's the district court information and the superior court information. So on this one, you can see they were initially charged in district court with trafficking a marijuana felony. And then it says in the disposition method, superseding indictment or process. And then you see superior court, the trafficking marijuana felony again. And then they were convicted, guilty to lesser possession with intent to sell and distribute marijuana felony. So this doesn't mean that there were two separate charges. It just means that they started off in district court. Superseding indictment just means that it moved to superior court, and then they were guilty to lesser. So you would only look at what they were convicted of, that highlighted portion. So you wouldn't have to put in trafficking of marijuana anywhere on the petition. If you found that this charge was eligible for expunction and it was granted by the judge, that would completely be erased as well. And then the verdict, disposed on, date, those just are the dates when they went to court. It was disposed finally, and it was a conviction. The law is over there highlighted that Courtney mentioned, and that's where you can look up the class of the felony. Okay, so again, we see here that there's the way that it looks, you could determine the type of disposition. So the top one is what a dismissal will look like. It'll have the communicating threats, misdemeanor, and there's no information on the second line because they weren't convicted. And then it'll say dismissal without leave, or it'll say deferred prosecution dismissal, or the other variants that Courtney already mentioned. And that is your indication that it was a dismissal. The convictions are the same we just saw, where it can be guilty to lesser, preferred judgment, guilty. Those all just prove that it's a conviction. And those, of course, the bottom one is the only one that you really have to pay attention to. Okay, and as she mentioned, there can be multiple charges all at once, and they can be separate charges on the same case file number. So here we see 3 different charges. They're highlighted in different colors just for ease of reading it. So the first one is a second-degree trespass misdemeanor that was dismissal without leave. So that one's a dismissed charge. Great. Second one is a assault on a female, and this one was actually a conviction. They were found guilty, and that's highlighted in green. And that one is separate from the dismissal, so 2 separate charges. Third one is another dismissal, communicating threats. And you can see they were all disposed on the same day of court. So they are separate charges. Again, 2 dismissals, 1 conviction. So you would have to put them on separate expunction petitions. And you can list, so the 2 dismissals, you would just list them separately and repeat the same case file number. That way they're both accounted for on the petition.
Sorry, before you
Yes.
leave from this slide. This is an example of a case that was pled to. This individual pled guilty to assault on a female in exchange for dismissal of the second-degree trespass and the communicating threats. You can tell that because under plea for the assault on a female, count 2, it says guilty. They entered a guilty plea, they were found guilty, and these other 2 charges were dismissed per plea. There is a place to notate that on the petition that we'll get to later, but this is what you're going to be looking for when you're trying to figure out if something was dismissed per plea. Did you have a question?
Yeah, that's an assault charge though. Is that eligible?
That's not going to be eligible, but the dismissals will still be
Okay.
eligible. Yes.
Yeah, so we do treat them like separate charges. We just have to notate those.
Right, when you see multiple charges under one case number, you want to determine the eligibility for each offense. So you're gonna go do the analysis for each of the offenses on here, and it may be affected by the other things that are on that record. But like I said, like these dismissals can easily come off this person's record.
All right, and then determining jurisdiction, I did briefly go over this already, but whenever you see the superseding indictment or process, again, that basically just means that it just moved to Superior Court. So you don't have to include the district court information on the petition or treat it as a dismissal because it's technically not. You would just consider what the Superior Court's final disposition is, whether it was disposed as guilty, not guilty, dismissed, et cetera.
And sorry, I'm gonna say one more thing on this one as well. When someone pleads to a lesser included, we can also get the originally charged offense expunged as a dismissal per plea. It's sort of an open question, but we haven't had much pushback, if any, from different counties. So you could put this trafficking in marijuana charge on a petition as dismissed per plea to the PWISD marijuana, and then at least the trafficking would come off. They would still have the PWISD conviction unless that's eligible under the conviction statute, but if it weren't, you could get the trafficking off their record anyway. And if the PWISD is eligible, then it all goes away with that expunction and you wouldn't have to do the trafficking separately.
Okay, so for probation violations and revocations, they do appear on criminal records. They themselves are not eligible. Basically, you would have to worry about the underlying charge that the probation is as a result of. And if you expunge the underlying charge, then the probation is automatically lifted as well. You can see here, so there was a possession of stolen goods property misdemeanor that was guilty, and they had a probation violation sometime later. But if you found that this charge, the conviction was eligible and it was filed and granted, then that probation violation would automatically lift as well. So the sort of different way that this can look is if it was an out-of-county probation violation, so they wouldn't appear on the same case file sometimes. So the last one we saw, they appeared on the same case file, but sometimes if it's out of county, it would just be a different case file in that county. So in this case, when it's transferred, again, you would not have to expunge that itself, but if after the underlying charge is expunged, it's still showing up on the criminal record search, then you could always just send a copy of the granted certified petition to that county's clerk's office so they could resolve that.
Okay, yeah. Go ahead. So we're going to talk a little bit about just practically how to go through a client's record. This PDF, this is kind of a screenshot of a PDF that we put together. Again, this is sort of pulling the data from the record onto this document, and then this document will allow you to fill out the petitions with a relative amount of ease. It will also allow you to hand it off to support staff. If you have a paralegal or a legal assistant who's interested in this kind of work, this would be a way for them to get involved and also to take something off your plate. All this information up at the top here under client information is what's going to go onto your petition. So you're going to want to make sure you're using your client's current address. All those addresses on the criminal record are not going to go on your petitions. It's going to be their current address. You want to note aliases, date of birth, race, sex, all that stuff so that when you go to put it on the petition, it's right there. You can just split your screen and type it in. Same thing for the next pages. So this first page is going to be sort of like a digest. When you sit down with your client, this first page is what you're going to look at and say, okay, here's the long and short of it. You're eligible for this. You're not eligible for this. We're gonna, submit petitions in 3 different counties for you for dismissals and in Mecklenburg for a conviction. That's just an example. Most of our cases, honestly, are going to be we're dismissing a bunch of Mecklenburg County dismissals for you, or expunging a bunch of Mecklenburg County dismissals for you, which is a pretty straightforward process. On this form, there are places to put every single case on somebody's criminal record so that when you sit down with your client and they say, well, what about this case? What about this case? You have it all at your fingertips. So the biggest section is going to be dismissals. Like I said, this is our bread and butter. We do the most work here with dismissals. You're gonna have a place for not guilties and acquittals, and all of these fields, they're slightly different for some of these because these are exactly the things that you're gonna be putting on a petition. Sections for misdemeanor convictions, felony convictions, and raise the age convictions. This is the area where you would put all the eligible charges. And then at the back of the record, you're gonna have a spot for all of the ineligible charges. And you can include a reason, you can include additional notes, and you can also check the box to say, this is your disqualifying one, so you can flip right to it and say, assault on a female, or this is a Class B felony, or something like that. And you're gonna take all that information and you're kind of gonna transfer it to your petition. And I'm not gonna spend too much time on this. It's pretty straightforward. You are gonna need separate petitions for each county, for each expunction type, and for each jurisdiction, meaning district versus superior court. But they're all fillable PDFs. They're on the AOC website. If you've ever had to do an AOC form for another case, like a civil action cover sheet or something like that, it's pretty straightforward. You're just filling in these fields with the information that you've already pulled from the criminal record, or having support staff do it. This is an example of a dismissal petition. Just a couple things to note here. The jurisdiction checkboxes at the top, the easiest way to figure out what jurisdiction you're in for a case is whether it is a CR case or a CRS case. S is Superior Court, CR is just District Court. So that's an easy shortcut for that. You're gonna put your name as the attorney under the name and address of petitioner's attorney for expunction petition. They're gonna send everything back to you, not back to your client. So while putting their proper address is important, it's more important to put your proper address because they're gonna send everything back to you, not to the client. All of these are made up, just so you know. I didn't put any real client's information on there. So that's the top half of the form. It's gonna be all your case information and your client's information. And on the bottom half, there's gonna be some check boxes that you're just gonna kind of have to read through and get a feel for. Highlighted here, you know, for charges dismissed per plea, you're gonna check that second box. And then again, you as the attorney can sign for your client on an expunction petition. For raise the age, as well as for adult convictions, there are some additional requirements. So there's going to be a filing fee. If a petitioner is indigent, that filing fee gets waived. All CCLA clients, we already screen for indigency. So this is kind of an easy one. Madeline will walk you through in a minute the petition to proceed as indigent. You also need to serve these petitions on the district attorney. We usually just do this by mail with a cover letter that says, please sign this and send it back. It will put the district attorney on notice that they have to notify any potential victims from that case because the victims have a right to be at a hearing if one is held. A hearing is technically required on raise the age petitions. I say technically, many times they don't hold one. If they don't, if they're not able to get in touch with a victim, they may just, the DA's office may, you know, say we're unopposed, a judge will sign it and send it right back to you. Same thing pretty much for adult nonviolent conviction petitions. So these same three requirements that are on the raise the age petitions apply for conviction petitions. And same situation with the hearings. There are two other things to note about conviction petitions for adult nonviolent charges. The first is that if someone has eligible convictions across multiple counties, you have to file all petitions within 120 days. We've run into some issues with this. If you have a client that has this, we are happy to assist and let you know what we've done that's worked in the past. The other big requirement is that they need to submit notarized affidavits with their petition. One from the client themselves, and then two from good character witnesses. We have templates for those. They do need to be notarized. Orchestrating that is usually the biggest holdup in getting convictions petitioned for. But not having these things doesn't mean you can't go ahead and submit someone's dismissal petitions, because there is no time limit on those. It only applies to the adult nonviolent convictions. And then this is a sample conviction petition from misdemeanor. Pretty much the same information as you're putting on a dismissal petition. And then the bottom's gonna look a little bit different. It's gonna have check boxes related to the waiting period, basically. And then I'm gonna have Madeline talk you guys through this because she is the one who prepares all of these for us.
What's the, so
Yeah,
when
sure.
you have to notify the DA,
Yeah.
what, can you go ahead and file, you go ahead and file the petition and notify the DA, or is that sequential?
It's sequential. You have to notify the DA first.
Okay.
There's some counties that do it slightly differently, but the best practice is serve the DA. And then when you receive service back, then send it to the clerk's office. Some DA's offices will send them to the clerk's office themselves. If you're trying to do petitions in faraway counties, CCLA is here to assist with those. At the end of the day, the best thing to do is to call the clerk's office or the DA's office and say, hi, how do you want this done? Because we want to make sure that it's getting file stamped or at least getting received at the clerk's office, not the DA's office, within that 120-day period. That's the most important
Because
thing.
my experience is they can take forever to get
Yeah.
back to you.
Yeah, we just had a case that took what, like an entire year,
Many years.
more than that, to get everybody on board, to get everybody in the loop. But you know, one county processed and granted the petition, and by the time they had done that, another county was requesting the criminal record, which showed that they already had an expungement, and so they denied. So we had to go, we have a brief now for that situation. We have lots of resources for those situations. But you know, step one is always going to be call the clerk's office, call the DA's office, see how they want it done, and then try to make sure the pieces are falling into place the way that you want them to. Honestly, the clients that we get that have this kind of situation are somewhat rare, I think. So we don't come across it too much, but when we do, we definitely are here to support anybody who's handling that kind of case. Yeah.
And I'm not sure if this is gonna be gone over later, but for after it's filed, once it's been either granted or, you know, denied for whatever reason by the judge, they do send it back and it needs to be certified by the clerk to be final, to be granted and certified. I just want to point that out because that's something that once you get it back and you see it's been granted or denied, sometimes we think that it's the end, but it does have to be either sent back to the clerk or for Mecklenburg specifically, you have to send 7 copies back, but they have instructions on that when they do send it. So just make sure that when you're, you know, looking at the final petition that you do verify that it has been certified to make sure that the expunction is actually taken off of their criminal record. I just want to point that out. Okay, so the petition to proceed as indigent, as Courtney said, we do already screen that all of our clients do qualify for this. They're within the federal poverty limit of that. So it is very similar at the top as you would do for the expunction petition. You can just kind of copy and paste that information. The county, case file numbers, jurisdiction, their name, all of that. The only thing that you would have to worry about here is you would want to select the option here highlighted, petition to file expunction petition. So you would select that, and then you would select they are represented by a legal services organization, CCLA. That will just automatically prove that they are indigent. You don't have to worry about SNAPs or any type of benefits to prove they're indigent. So you select those 2 boxes, and then a notary has to complete the bottom portion here. I am a notary. I'm sure if you work at a law firm with paralegals that are notaries, they could always do that for the clients. If the client thinks that it's easier to just take it to the UPS store and get it notarized, they're more than welcome to. But you know, we do notarize for free for our clients because many of them can't afford the $10 that it takes to do that. So that's always an option. If you know paralegals at your firm are able to do that, then just let us know. We'll try to coordinate with the client to get that notarized and return back to you. And then at the bottom, that's where you'll put your information as the attorney. We won't put our information since it's gonna be along with the petitions that you're filing for the client. So just make sure that you fill out all the stuff in yellow, and then you can go ahead and fill out the name and address of the petitioner, so the client's name and address, or the client can do it themselves when they're in person with the notary to get that done. But yeah, so that's the petition to proceed as indigent to waive the filing fee. Sorry. Okay, so Courtney's mentioned a couple times the Expunction toolkit. So we do really have a very robust resources for the pro bono attorneys that take cases with us. We have a very in-depth toolkit that we provide you. It will have the PowerPoint, and the PowerPoint that we're going to include in the toolkit is an even more descriptive version of this one. It gets into even more of the nitty-gritty differentiations and clarifications. We just wanted to keep it as simple and kind of an overview as possible, but that will have even more helpful information if you decide to take a case. And there will also be guides and frequently asked questions, so you can control F certain information, make it very easy. We also have the eligibility determination form that Courtney just went over, and we have the felony classification list and the misdemeanor classification list PDFs, so you can also control F in there, and that will help you just very quickly locate the information you're looking for. We also have all of the links to the AOC forms directly. We include the links because if for whatever reason they were updated, we just want to have the most up-to-date forms available. The model affidavit, so the templates, and it'll show you where you put the information on the templates. Sample cover letters to the DA, the clerk, the arresting agencies by county that I mentioned earlier, and the expunction filing information by county. So I believe that was also briefly mentioned, but basically, some counties accept filing by mail, some may require, in-person hearings, et cetera. So that will just have every county that we've been able to contact and verify their filing requirements. The toolkit also has the closeout information. So it'll have the online closing form and the example cover or closing letters and the clearinghouse form. So the clearinghouse form is really important because even if the charges are taken off of the formal statewide background check systems, some landlords and some employers, they will use private background check companies, and sometimes those records have not been updated that the expunction was approved and granted and certified. So the clearinghouse form just notifies the agencies that, okay, this expunction happened, these charges are no longer on this person's criminal record, remove them from your database. So this just helps to ensure that the expunction doesn't, like the expunged charges do not show up on any records for the client.
And we'll talk a little bit more about the clearinghouse form at the end as well. I just wanted to go over really briefly some other relief that's available if you're talking to your client and they ask about these things, just so you're aware of them. Pending charges. For recent pending charges where someone has a future court date on their criminal record, clients should have their own attorneys on those cases. We can't really help them with something that's, they have a court date for in a couple weeks. You should tell them, you got to speak with your public defender, you got to speak with your attorney for those. There are, however, unserved charges that may appear on someone's record. A lot of time, clients aren't even aware of these. They have an unserved charge in a far-off county that they are completely unaware they were even charged with. A lot of them are years and years old. And what we want to do on those, if we can, is try to negotiate with that DA's office to see what we can do to help get that charge resolved so that they can get convictions expunged and or get that charge expunged. And the same goes for charges that were voluntarily dismissed with leave. Sounds like a really fine distinction, but what it basically means is that the DA's office can reinstate this charge at any time. They do this a lot in batches with older cases that have been sitting on the books for a while. The clerk's office and the DA's office will just go through and clear out a whole bunch of case numbers. And again, the client won't even be aware that this charge is out there. But for the most part, what we're going to be doing with those cases is reaching out to the district attorney and asking for them to dismiss the charge. With old victimless cases, like a misdemeanor larceny from a Dick's Sporting Goods in 2001, most DA's offices are gonna be like, sure, I'm gonna go ahead and get that off that person's record. We can immediately get that expunged. It means they can be eligible to get all these other convictions expunged to the extent that they have them. It's a really great thing to be able to do for a client. I did it for someone for a DWI, and they were pretty thrilled. And we were able to get that dismissal off their record as well. And really, this is just sort of using your network. If you know any DAs, if you know any public defenders or criminal defense attorneys in Mecklenburg or in other counties, they can kind of tell you who to talk to, who to email, and just kind of start there. It's really one of those things where no one's going to give it to you if you don't ask. And sometimes that's all you have to do.
And we have that network available.
We
too.
also have the network too. That's right. Certificates of relief are something that sometimes clients will ask for by name. I'm not going to go through all the criteria necessarily. It's a lower bar than expungement. It's not an expungement. It's kind of like an expungement light. It's like a recommendation letter from the court saying this person's had their record clean. And it's most useful for people trying to get state licenses for things, because state licensing boards can deny someone a license based on a criminal record. But if they have a certificate of relief, they cannot deny them the license based on that charge. So that's just something to be aware of. If someone asks about it, again, we're here. We have more resources about certificates of relief. They are some hoops to jump through. So unless someone has concrete reason that this is really going to help them out, we don't usually pursue them or offer them to clients. Motions for appropriate relief are kind of a catch-all. It's like a post-conviction relief type thing. It's a motion to correct an error in legal proceedings. Again, we don't really use this very much. It's just sort of something to be aware of. If someone tells you something about a case that seems really wrong and egregious, you might look up some information on this and see if there's any way that maybe they can get an MAR to get a sentence vacated or something like that. And then driver's license restoration is another thing that clients ask about a lot. We are limited right now in our ability to take driver's license restoration cases, but Legal Aid of North Carolina has started taking them, and the Pro Bono Resource Center offers free advice letters if the clients go to ncfairchance.org. It will basically tell them everything they need to do to get their driving license restored. I just wanted to go through really quick expectations and step-by-step what it would actually look like to handle a case, an expunction case from CCLA. Basically, what would happen is Laureen Kickham is the pro bono paralegal at CCLA. She's the one, she'd kind of be the first point of contact. And she's going to provide client information for conflicts checks. And once those have cleared, you're going to get a case file as well as a bunch of resources. The case file is going to include, like we have discussed, the Cypress record, the Lexus record, the client's information, how to get in touch with them, their representation agreement, and then all of these tools that we have just gone through in the toolkit. And the first thing you're going to do is logic game the record, figure out what's going on with this record, fill out that determination form, and then send it to CCLA so that we can just kind of double check and make sure that we're not missing anything before you go and talk to the client. The second step is going to be to talk to the client, go over their record, make sure it's complete, and then tell them what is expungible and what isn't. We are asking that attorneys contact their clients within 30 days of receipt of a case file. Obviously, we're willing to work with anybody that has something come up or reassign a case as need be, but that's kind of what we're aiming for when we assign a case out. And Laureen will kind of check in with people along the way if she doesn't hear from an attorney about how things are going with their case. Just a note on this, it is sometimes difficult to get in touch with clients that come to us for expungements. The number one way that we found to get in touch with them is by text. So if you wanted help texting, we can show you how to set up a Google Voice account, or we can text them for you just to make that initial contact, because that can be sometimes the most difficult part of an expunction case. The next step would be to prepare and file petitions. We would also ask that you send those to CCLA, the drafts, before you send them out. So again, we can just double, triple check, make sure that if there's anything easy, to fix, that it won't get rejected for something that we're used to seeing that maybe a pro bono attorney isn't. And then we would ask that attorneys monitor their case status and take necessary action. So this sometimes involves a court appearance, but if you guys are transactional attorneys, we can make sure that you get a case that's not going to involve a court appearance, and is just going to involve, every 2 months calling a clerk's office and saying, hey, here's my case numbers, what's happening with this expungement. And then the last step is going to be to close the case. Again, we are here to help. Janan is actually the managing attorney of the Consumer Empowerment Project. She's out on parental leave right now, but her email address is here since she'll be back and be able to answer questions. I'm always available to answer questions, and we will be reaching out to kind of check in on attorneys. These are some tips for advising the client. Some of them I've kind of gone over. I think the number one thing, especially for any attorney who has dealt with clients before, it's the same thing with expunction clients: manage expectations. This can take a long time. This can take up to a year to get, after you file the petition, to get the petitions back. Luckily, clients are usually so grateful to have an interaction with someone who's trying to help that it's not that difficult of a thing to do, but it is important to set it out right at the beginning. And again, I just wanted to emphasize that we do want to make sure we're discussing the completeness of their criminal record. This is most important for these nonviolent convictions because of that 120-day rule. If we file for a bunch of dismissals and then we find out they have more dismissals, that's not that big of a deal. But we're going to essentially waive the right to petition for things that aren't on that record if they don't tell them that, if they don't tell us that, something's missing. There is, another argument you can make that you have good cause, that you pulled the record. And if you had to go down that route, again, we have resources to help out with that. But that's the importance of discussing their criminal record with them. And then when you're advising their clients, these are just some of the most common things that we hear clients asking about. Who has access to my records after they've been expunged? It's important that they know that DA's offices and courts can see those records. They can use them to determine prior record level if they reoffend, and they can use them for 404B character evidence if they reoffend. So that's important for them to know. However, they don't have to disclose any arrests or any convictions for things that have been expunged. So if an employer asks them about it, that's actually prohibited. They can honestly say, no, I was never convicted, I was never arrested. Even if they're on the stand, they cannot be prosecuted for perjury if they testify under oath that they don't have any convictions, if they were lawfully expunged under these statutes. And then we do ask that you all follow up, like I had just mentioned, every couple months. If you don't hear back from a clerk's office, just call and check on the status of an expunction petition. Sometimes your clients will help you remember to do that by reaching out to you. And then after expunctions are granted, what you're gonna do is provide your client with the certified copies of the original petitions. So when you get back those copies of petitions with the raised seal on them, scan them, make a copy for our file, for CCLA, for you, and then send the originals to the clients and explain to them the clearinghouse process. This form here is in the toolkit. It's pretty straightforward. They have to submit one for every petition that was granted. But basically, the Foundation for Continuing Justice is going to handle notifying all these private databases of the expunction so that those databases can remove the information from their system. This is just a list of some additional resources. Most of our pro bono champions that I've talked to find the first one to be most useful. It's a pretty comprehensive guide. It is from 2022. So you may need to just double, triple check everything is current, but really the main only change that I saw on there is the 120 days. It used to be 30 days that you had to file all petitions across the state. Now it's 120. But other than that, it's pretty much up to date. Again, our email addresses are down here. And there are some other resources on here as well that I listed just in case you're looking to go all around the internet to look for an answer before you email one of us. This is a big asterisk. Mecklenburg County is getting on the e-courts train on October 9th, and we will have to file through the electronic system. I have spoken with attorneys who have been working through this process in Wake and other counties. Some things are going to change, even some things that I just told you might change, unfortunately. And we're going to figure that process out and then hold a follow-up training, which we'll post. But that's future us problem. For right now, really, we're just trying to get you all excited about expunction so that you'll take cases. We will work this out. In some ways, I have heard this is easier and faster, and we have really good relationship with the clerk's office and the DA's office here, so hopefully it will go smoothly for us, but I know there have definitely been bumps in the road for the other counties that have gotten onto e-courts. So I don't know how we are on time, but if anybody has any
We
questions.
did have a question in the chat. It says, what if we are licensed out of the state, referring to taking a case?
It's 4:15, we're good. And I can answer that if you like.
Yeah.
Okay, if you are, I'll stand up here. In North Carolina, you can petition to practice pro bono under the supervision of a legal services organization if you are licensed to practice in another state. So the way that it works, you can reach out to any of us and we can provide you with the information. You just have to get your certificates of good standing from anywhere that you are admitted and submit them along with a petition and a statement from a supervising attorney. That could be Courtney or me or anyone else at a legal services organization that you'd be working with. That will go to the bar, and then the bar meets quarterly to determine, I mean, I've never seen it not granted. So they meet and they'll grant it, and then you are free to practice. Alternatively, if you don't want to go through that process, you can reach out to us and we can try to find you someone that you could partner with. But I definitely recommend taking advantage of the petition to practice pro bono, and also for retired attorneys, they have a similar process. And any other questions on the chat?
There were in the chat. Anybody in the room have any questions? Yeah.
So just two quick ones. One, I assume you just get this from the client, but if not, is there anywhere other than from the client that you can learn whether the sentence is complete? Like looking at the records, it doesn't seem like that's very clear.
Yeah, so the records that we provide is not going to be on there, but the Cypress system has case details that we can access. If you need the case details to get a sentence, you can either email a request to us and we'll pull it and send it to you. Or if you go to the courthouse a lot, there are actually computer terminals at the courthouse. They're right on the second floor to the left of the clerk's office, and Cypress is available there. You can just go in and look up your client's cases in there and find the case details.
Okay, really
It
helpful.
takes a little getting used to the system, but that stuff is definitely in there.
Okay, great. And then the other question is, so with probation violations, you mentioned that if the underlying charge is expunged, so probably a dumb question, but just to make sure, when you say underlying charge, are you referring to the charge that led to the sentence of probation, or are you referring to the charge that led to the violation of the probation?
The charge that led to the probation sentence.
Okay.
Yes. And just when you're going through your determination form, you don't even need to put the probation violations. There's just no separate grounds to expunge a probation violation if the charge that they were sentenced to probation on is not eligible. But yeah, and not all probation violations are the result of new charges either. They can be just violating a condition of probation that's not a criminal offense in any other way except that it violates probation.
Thanks.
When you do the follow-up training on the e-filing, I'd like to have my administrative assistant attend because she handles all of that for me. So I think that would be super helpful.
Yeah, sure. That will most likely be virtual.
Okay.
And that would be recorded, and we'll also put it on the toolkit as well.
Just follow up to that. Did you say that there were other counties that are doing e-filing now for this?
Yeah, there are pilot counties that are doing e-filing, Wake, Harnett, Lee, and I can't remember the fourth county. And we have kind of like a statewide working group of attorneys that have been working in those other counties. And it's been a bit of a challenge. So hopefully there's some kinks that are worked out. There's some things that we will benefit from having such a good relationship with the clerk's office here, hopefully. So if you have a case right now and you have dismissals, file them immediately. This recording will also be available. Right now on our toolkit page is kind of my dry run training that I did to this PowerPoint presentation. So we're gonna take that one down and put this one up.
And I'll just add one last thing before any other questions. So Courtney did mention like contacting the client. So it is really, really important to make sure that you tell the clients when you first discuss with them, their criminal records, just tell them to keep you updated on their contact information changes. Many of our clients, some may be homeless, some may be in shelters, some may just have unstable housing because of their criminal records. So they sometimes change phone numbers or number may be out of service. Don't necessarily think that if you call them and it tells you it's out of service that they are just MIA, you can no longer contact them, because we do have addresses on file. You can send mail. We have email addresses. You can follow up by email, even text to the same number, and they might receive it once they get their number back in service. But just make sure that you do relay that to them to keep you updated on their changes, and also just try more than one avenue of contact with the clients.
Is there a question?
Yeah, with regard to restitution, does that show up on when they're done paying back? Does that show up in the system, or did I hear you right that they could also be judgment?
That'll show the civil judgment. That will be in the case details, the additional information about a case. If you find one that you need that information on, we can go ahead and pull it. The date of their final payment will be in there. That's really tricky sometimes to figure out exactly when it was, unless you know the system. So if you get a case that has that situation, one of us can walk you through exactly when and why this is the date that the clock starts, so you can explain it to the client.
And then I think one of your first slides said that with felonies, it has to be within a 24-month period.
Mm-hmm.
Is that the date of the offense or the date of conviction?
That's the date of the offense. They have to have been committed within a 24-month period.
And on the date of offense, that's the arresting date as well, unless otherwise stated. And that's what you use, that date is what you use when determining the age at time of offense, whether it would be considered the youthful offender or adult conviction.
Yeah, the date of offense and the date of service or arrest are usually going to be the same, but not always. So that's kind of an important thing to look at. You're looking at the date of offense in deciding age and in deciding that 24-month period. But it's certain charges, like, for example, larceny larceny by employee. A lot of times the offense date will be in February, but the employer didn't find out about it until March, and then they didn't get charged until September or something. So you might see a difference in those dates, but usually they're going to be the same. The person committed the crime, police showed up and arrested them. That's going to be same service date as offense date.
And I'll just close. So for anyone who doesn't know me, I'm Casey. I'm at CCLA running the pro bono department. However, Friday is my last day. So Courtney will be the person to go to from here on out for literally all things. What is the toolkit? Just so we're all clear, we used to use just a zip drive that we sent. The toolkit is now online. So if you go to Charlotte Center for Legal Advocacy and you click on volunteer, there will be a password protected portal to training and resources, and that's where you can find everything that was mentioned. This has been approved for CLE credit. So if you're on the Zoom We should have your information. If you're in the room, please make sure you see me if you're looking for North Carolina CLE credit. I want to introduce our Triage champions. Triage is sort of a special program here in Charlotte. And one of the things that we do through Triage is we have people from firms or from the corporate counsel offices who sort of act as our champions. For expunctions, that would be Ms. Laura Nichols from Duke. That would be Patrick Durr from Winston-Strawn and Eddie Nogay, I lost you, from Troutman Pepper, and also Nicholas Lee from Parker Poe. So you can reach out to them with questions. They're the ones who, if we start getting a lot of cases and not enough volunteers, that's going to be that knock that you hear. Please take a case. And we expect them to be very relentless in that pursuit. After this training, Lorraine Kickham will reach out to everyone and see if you're interested and ready to take a case. If you do decide to take a case, you will run your conflict check. We'll send you the case with the toolkit information, and you're going to be connected to, Courtney and Madeline. So we want everyone to really feel that they're going into this supported. We will review your determinations. If you're just not sure about anything, you can ask us at any time. And we will review your petitions as well before you file them if you'd like. So pretty much at any step in the game, we'll be there. The plan is also to hold some office hours in the next few weeks. So we're just gonna set up a Zoom link. We'll set up the time for those. And if you've received a case recently and you wanna sit in on maybe other people's questions or ask your own question, you can hop on the Zoom link and Courtney will be there to sort of answer any questions that you have, just for that sort of extra added level of support. Finally, if you are interested, we can do these trainings at your firms or at your office. If you're like, I have people who weren't able to attend, but I think I've got 5, 6, 7, 10 attorneys who might be interested. We will come, we will give this presentation. You can all take a case at the same time and kind of work on them together. And we also do clinics. That's something we've really been working on recently. So if you maybe want to partner with a corporate counsel office or with a firm, we can set up a clinic and do sort of mass expunction work in a sort of day-long setting. So there's lots of ways to get involved. So thank you all very much. The reception for those who are going is at Grand Bohemian starting at 5. So hopefully we will see you all there.
And I'll just make one plug. I think I've been one of the expunction champions from the get-go.
Yes.
And Duke Energy has really taken to this program because we have a goal for all of our folks to participate in pro bono, not just the attorneys. And this is something that our paralegals and admins can really do something substantive because they can help with organizing everything. They can help once we talk to the clients and determine the eligibility. They can do all the paperwork. And so it's something that I know I've worked very closely with my administrative assistant on all of mine, and she really feels very good about it, as do I, when we're able to help someone put something in their past in the rearview mirror and move on with their lives.
Yeah.
So if that is something other companies or firms are looking for, this project is really great for getting your whole office involved, not just the attorneys.
Yeah, thank you. That's a good point.
Yeah, I was just gonna say to that end, we just started doing the clinic at the courthouse. And for that, we get volunteer paralegals and legal assistants from across the state. I think this time I don't remember if we recorded it or not. But we will or do have a training specific for support staff drafting petitions that we can also make available on the website.
Oh, that'd be great. Yeah.
Okay. And then that's just, your paralegal, your legal assistant can just watch that. They don't have to watch the whole 60 to 90-minute presentation.
Thank you. All right, thanks everyone.
Thank you.
Thank you.